There are a variety of institutions in this country that I have to be honest with you, I've looked at for a long period of time now and thought, are you really part of the democratic fabric of this country or are you not? As you know, local government bureaucracy has been number one in that particular area, although the upper reaches and echelons of the senior public service in Wellington would be right up there as well. But another that I've increasingly got to the view of that we cannot trust, that are actually anti-democratic, that are utilising branches of public law to advance their own agendas, is the Supreme Court and its lesser courts in this country. A judicial system that really does believe that it's part of the political process rather than an enabler of the legislative and executive to get things done. It is in actual fact on an equal, and I would suggest to you in some quarters, on a superior path, certainly intellectually, to that is our democratic institutions. I'm obviously not the only person to say this, and that includes Roger Partridge, who is the chair and a senior fellow at the New Zealand Initiative. He's written on this particular issue, and particularly on an issue we thought had gone away. And as Roger Partridge has pointed out, no, it has not. And this is to do with the seabed and foreshore issue, the Marine and Coastal Areas Act. To take us through this and why we need to be concerned in 2025 that the Supreme Court is still composed and thinking the way it is, Roger Partridge joins us now. Roger, thank you so much for joining us. Lovely to have you on the program.
Good afternoon, Michael.
You're absolutely right. And when I read your article of a couple of weeks, it might be a week ago, in the New Zealand Herald, headlined, "The Supreme Court's Rush to Judgment is a Constitutional Wake-Up Call." Because I'd relied upon media reports, Roger, was under the impression that the Supreme Court had pulled in the heads of the High Court and the Court of Appeal to do with their interpretation of the 2011 piece of legislation called the Marine and Coastal Areas Act. And I thought, good, I can now go back to sleep again. You're saying to me that might have been the impression you got, but that's not the right impression. Can you tell me why?
No, that's right. At first blush, it did look like the Supreme Court had walked back the expansive interpretations from the High Court and to a greater extent even the Court of Appeal, but that's not right. It's pulled back from an aspect of the Court of Appeal's decision over when iwi can claim customary title to marine and coastal areas. But the bigger problem with the lower court's decision still remains.
Now, could you just take us through what the issue was in this particular area? I mean, my thrust of my interview today, Roger, will be on the activism of the Supreme Court rather than on the pros and cons of the coastal or iwi claiming particular coastal areas under common law. But can you take me back, please, to what the problem was that I think Edwards case was designed to solve?
Yes, and look, I completely agree. The issue is much bigger. The issue with the Supreme Court is much bigger than this particular case. But let's just dive into it. You might remember the Marine and Coastal Areas Act legislation was passed in 2011 by the national government with support of the Maori Party. It replaced the foreshore and seabed legislation. And Parliament crafted a quite careful two-stage test to determine when iwi have traditional rights over coastal areas. The two steps were, first, iwi have to show that they have a traditional connection to the area in accordance with tikanga, Maori customary practices. And then secondly, they must prove exclusive use and occupation of the area since 1840 without substantial interruption. And crucially, that second limb is drafted without reference to tikanga. In the High Court in the Edwards case, the judge decided the second stage needed to be assessed or evaluated in accordance with tikanga principles. So really just riding roughshod over Parliament's careful test. And that allowed the court then to go on to say, well, we have to interpret substantial interruption and exclusive use and occupation in accordance with tikanga, and that's broad enough to include shared use. Well, that's the antithesis, you might have thought, of exclusive use.
Yes, it is.
And then when we got to the Court of Appeal said, well, substantial interruption doesn't mean any substantial interruption. It can only be substantial interruptions that have been expressly authorised by statute. And of course, that substantially narrows the range of substantial interruptions possible. So we have in combination a radical reading down or lowering of the high threshold Parliament set for iwi to make claims under the Act. The Supreme Court said that the Court of Appeal had erred in saying substantial interruptions could only be interruptions authorised by statute. Any substantial interruption will do. Mm. But they continued with the lower court's view that exclusive use and occupation needed to be assessed in accordance with tikanga, even though Parliament had deliberately not included tikanga in the second limb.
They basically added tikanga to suit what? Their view
to enable a wider approach to exclusive use and occupation. So taking a more expensive approach to when iwi can claim traditional rights over coastal areas than Parliament.
So just before we get into the wider area, what's the practical effect of that judgment, that there would be likely to be more successful applications for rights,
for customary rights? Yeah. Yes. Well, rights under traditional rights over coastal areas. Yes. If exclusive use can extend to shared exclusive use, then that will capture a greater proportion of the coastline, and so that's the court's view on how the test should be applied. But it appears pretty clear that wasn't Parliament's view when it passed legislation. And of course, in our constitutional framework, Parliament is supreme. It sits above the courts, and the court's job when interpreting Parliament's legislation is to give effect to what Parliament intended, not to stretch Parliament's words to reach an outcome the courts might prefer. And that's what we're seeing more and more. So this case is an example of a bigger picture where the courts are increasingly stretching or even ignoring Parliament's language to create outcomes that they prefer when applying legislation to a particular set of facts.
And that seems to be part... Sorry, Roger, but that seems to be part of a wider thrust here. I think I've read speeches by Glazebrook and other Supreme Court justices arguing that when it comes to Māori issues in general, tikanga has a critical role to play in interpreting the law.
Yes, that's right. Here, the courts are reading tikanga. The court is reading tikanga into a statutory provision, but in the Ellis case, which you and I have talked about previously, and which was discussed in my report from earlier in the late last year, the Supreme Court did take an extremely expensive approach, throwing out a century's legal theory in favour of its preferred approach to tikanga, and in doing so creating enormous uncertainty in the law. This is a slightly different issue. Here they're reading tikanga into legislation when Parliament left it out. And that's unquestionably activism. It's unquestionably not the court's role. And it's one where Parliament needs to act to correct the position.
Okay, well, let's deal with that. When there was an indication, was it from Simon Watts? It was that they would intervene.
Well, it's part of the. It's in one of the coalition agreements. I think it's National and New Zealand First, that Parliament will pass laws to correct the court's erroneous decisions in this area.
Yeah.
And that's perhaps the more concerning part even in relation to the Supreme Court's decision late last year, because Parliament was poised to debate an amendment bill to correct the position in December. And the Supreme Court rushed its judgment out to get it out ahead of Parliament's deliberations, right on the eve of Parliament's deliberations. Understandably, that's caused them to be deferred while the Crown takes advice. But the court used a very unusual approach to get its judgment out quickly. It had heard arguments from 19 parties just 2 or 3 weeks earlier, and you'll be familiar with how slow the court process usually is. Judgments can take 6 months or a year to emerge. Yeah. Here they got what they called a first judgment out, addressing the legal question and setting out their view. And it's almost impossible to avoid the inference that they got this first decision out. It didn't resolve the issues in the case. It just said, well, this is what we think the law is, and then we'll come back with a second judgment later. Well, that's a very unusual step for the court to take. And it's almost impossible to avoid the inference that they did that so that they could influence Parliament's deliberations. And that's not the role of our courts. The courts aren't supposed to have an agenda. They're supposed to be impartial arbiters of disputes.
Yeah.
But that's a sign of a court that sees itself as a political actor, and that's not consistent with our constitutional framework.